We first will have Duell Ross of the Legal Defense Fund.
Thank you. I also wanted to thank my clients, Representative Sewell, Scott Douglas, Shalala Dowdy, Letitia Jackson, Kadita Stone, Evan Milligan. Thank you all for being here and for all of your incredible advocacy, as well as my co-counsel at the Legal Defense Fund, and Abba Khanna, who did an amazing job, as well as her co-counsel. We're here because of the incredible work that our clients have been doing over many decades, fighting for fair maps and fighting for opportunities to ensure that the Voting Rights Act remains strong. As we know, the Supreme Court over the course of the last several decades has issued a number of rulings that have made it more difficult for Black voters to bring these claims and to, have their rights protected. But we feel confident that the facts here are so egregious in Alabama, the fact that it splits this Black community that has existed in the state for 200 years, and that really has egregious conditions, the lack of portable water, the lack of adequate sewage, all things that having more representation, responsive representation, would really help improve for Black voters in the state. We're not looking for any kind of guarantee of representation. What we're looking for, what my clients are looking for, is a fair chance, an equal chance, the same chance that white voters have, who are only 63% of the population, but control fully 85% of congressional districts. And so I thank you all again for being here. I thank, again, everyone for all of the incredible work that we've done and will continue to do.
Now we will have Abba Khanna of the Elias Law Group.
Thank you, everybody. Abba Khanna, on behalf of the Castor respondents in this case, I just want to begin by thanking our clients, the National Redistricting Foundation, which has been just an incredible partner for this case and so many others, and really fighting for ensuring that voters across the country are voting under fair and lawful maps. I want to thank the individual plaintiffs, so many of you who are here today, for really standing up and calling out an injustice where there was. I really want to thank my co-counsel here, Duell Ross of the NAACP Legal Defense Fund. I'm extremely proud to have stood up there alongside you in the Supreme Court and to have done it as trial below. It has been a real pleasure and an honor. This is one of the most important redistricting cases to come before the court in many years. And at bottom, the Voting Rights Act is really about securing a very fundamental and basic promise, which is the promise that every American voter, regardless of their race, gets to have the equal opportunity to elect their representatives of choice. And in Alabama, that promise was broken. And 3 judges below found that this was a very easy Section 2, straightforward textbook Section 2 violation, where Black voters still today do not have the same opportunities as other members of the electorate. We don't ask much of the Supreme Court today. We ask them just to reaffirm the same precedent that it has held for 40 years, and that states and minority voters have relied on in that time. And I think it's, Mr. Ross mentioned the disparity in the populations and the various representation that they have. I think another interesting data point is that over 92% of white Alabamians live in what are really supermajority white districts. And what that tells us is that there really is no incentive for elected officials to reach across facial lines to respond to the needs of the Black community. And we're hopeful that our case, and hopefully a positive result in our case, will lead to something that actually leads to better progress and that realizes the promise of the Voting Rights Act for Black Alabamians.
Thank you. Now we'll have David Rossborough of the ACLU.
Good afternoon, everyone. Davin Rossborough from the ACLU Voting Rights Project. We're co-counsel in the Milligan plaintiffs. I want to echo everyone's thanks here to all of our courageous clients here. to amazing co-counsel from Legal Defense Fund, from the ACLU of Alabama, from Hogan Lovells, and the amazing team representing the Castor plaintiffs as well from the Elias Law Group. Alabama's maps haven't changed much in 50 years. That was a statement from Alabama's own brief defending their maps here. And it's an amazing thing that they're defending it this way, because in the early 1970s, George Wallace was governor. Alabama had an all-white state legislator, and it would be 20 more years until Alabama had even one African-American congressional representative. And that only changed, of course, because of organizing people like our clients here, but also because of the Voting Rights Act, the passage of the Voting Rights Act. It was litigation in the early 90s that produced even one district in which Black Alabamians could elect a candidate of choice. And so now when Alabama wants to go back in time and entrench discriminatory districts forever, I mean, we should take them at their word that that's what's happening. But Black Alabamians, and particularly those in the Black Belt, and in fact, all Alabamians deserve better than that. Under any vision of the Voting Rights Act that respects Congress's purpose and the text of the act, Alabamians deserve better maps. They deserve fair maps that are not racially discriminatory. The Voting Rights Act was meant to be a powerful weapon to fight against districts that entrench white supremacy. And as Alabama shows, it's still desperately needed. We hope and believe that the court will follow the purpose of this law and not weaken it. Thank you.
We will now have lead plaintiff, Evan Milligan.
Thank you. I won't take up too much time. I do want to say really just hats off again to our counsel, to LDF, ACLU Alabama, the folks at Hogan, and if I'm missing somebody from our cast of characters, please charge that to my head and on my heart. One of the things that we've tried to say as plaintiffs, or at least that I've tried to say more recently, is I wish folks could have a real good sense of who these plaintiffs are. Standing behind me, you have a country singer, you have someone who's starting their first semester of law school and may even be doing some homework behind me now, may or may not be. You have a very sought after political consultant. You have, someone who's been directing civil rights organization in Alabama for one of the strongest ones for over 30 years. And I could go on and on. Veterans, commanders in the Army, all the way to anti-war activists. You have people who are very devout believers and some skeptical non-believers represented in our plaintiff group. And we model a type of diversity that we're very proud of in our state. We model connection to leadership, development traditions, to advocacy traditions, where we don't always think the same way. And it's really important to affirm that diversity, because it actually gives us something to be hopeful for now as we look in our country and we see this drumbeat around how too much diversity or having too many opinions makes a society that is somehow less manageable. And as advocates for democracy and multicultural democracy, we really believe that it's actually even more possible to have a more equitable society when we have different people. Is really just developing the sort of process we need to listen to each other. We've tried to do that as plaintiffs here. And in the courtroom today, I think we all heard a really interesting argument about when we should be race conscious versus race neutral. And I think you heard the state of Alabama actually say, well, if there's race in those lines, if there was race in the lines, then I could see us adopting a race conscious approach. And then one of the justices said, well, if you were trying to identify if there was race in the lines, what rubric would we use to do that? And then they say, oh, well, we have to be race neutral at that. So it's like, well, how do we, so if for those of us who work in that landscape as Congress people, as lawyers, as advocates, we're being gaslighted like that all the time. it makes, you can feel like you're literally being driven insane. And so to have lawyers that can stand up and put on the record the history of the state, but also it's affirming for us in a way that's beyond words. And hopefully what the court will see when they hear that argument is something that really affirms the Voting Rights Act and affirms our democratic tradition. So we thank you all for standing with us. And I don't know, are other plaintiffs allowed to? Okay, so Troy is gonna come up. So thank y'all again.
Next, we'll have Plaintiff Shalila Dowdy.
Medgar Evers, Jimmy Lee Jackson, Vernon Dahmer, James Reed, Viola Gregg Luoso, Reverend Dr. Martin Luther King Jr., and so many more are all civil rights activists whose death can be attributed to the fact that they chose to fight for voting rights, specifically on behalf of Black Americans. They stood 10 toes down, instilled fear in some and pissed others off, all while remaining brave and having the courage to fight to make sure that Black people had a voice in this democracy that we call America. The Voting Rights Act was signed in 1965. I was not born. My mother was not born. But yet here we are 57 years later, still engaged in the fight for voting rights. Sometimes I ask myself, how is it that we're still fighting? You would think that after the passing of such bills as the Voting Rights Act, all would be well and we could rest and cease with the fighting. But what we are now in America, in the American society, we are reminded that there are forces working against us. There are people who want us to have no significant role in how America is developed and shaped, and prefer for Black Americans to be silenced and not have any power. Throughout the years, there have been obstacles and voter suppression tactics put in our way to prevent us from voting, such as the fear of being lynched, having to pass literacy tests, having to recite the preamble from the Constitution, being asked how many bubbles are in a bar of soap, having to pay a poll tax, and so much more. Today, the voter suppression continues, but in disguise, through voter ID requirements, lack of language access, voter roll purges, polling place closures and consolidations, no early voting in some states, such as Alabama, reduced early voting in others, reduced voting hours, lack of same-day registration, lack of automatic voter registration, and the list goes on. I'm sure y'all get the point. But now we are faced, and we have always been faced, with the voter suppression tactic of gerrymandering. The gerrymandering of maps that dilute Black Americans' votes and us having the opportunity to be able to elect the candidate of our choice. The outcome of Milligan versus Merrill will impact Black voters not only in Alabama, but throughout the entire southern states of America. This case will determine whether Black Alabamians will be heard or silenced. The case will determine whether Black communities will get the proper support and funding that is needed concerning healthcare, education, and infrastructure. The voice and livelihood of Black Alabamians are at stake of being silenced and destroyed, and because of that, we fight. Elections allow voters to choose their leaders, but redistricting within Alabama have allowed elected officials to choose their voters. Therefore, redistricting and fair maps by itself is of the utmost importance. If the lines are not drawn fairly, voters are not able to go to the polls and make a fair and adequate vote. There is power in our vote, specifically the Black vote, and that power has instilled fear in some people so much that they are strategizing on ways and continue to strategize on ways to dilute that power and take it away. If we don't speak on race and make it about race, Black people won't get the representation that they deserve. History shows us if we are not vocal about our problems, Black people will not have a seat at that table. We'll be on the menu. MLK stated in a speech centered around voting rights, "Give us the ballot, and we will fill our legislative halls with men of goodwill and send them to the sacred halls of Congress." We, the plaintiffs in Milligan versus Merrill, say give us fair maps that do not dilute the Black voting power in the state of Alabama so that we can send an additional representative to Congress who will take into consideration the issues that Black Alabamians are faced with and fight for us alongside the other constituents in the district. We do not want to be forgotten. Thank you to the NAACP Legal Defense Fund and the attorneys from the Castor case. We appreciate the work that you've done and choosing to fight this battle with us. Thank you.
And to close out remarks, we are going to have Congresswoman Sewell.
I'm Congresswoman Terry Sewell, and I proudly represent Alabama's 7th Congressional District. It includes the historic civil rights cities of Birmingham, Montgomery, and my hometown of Selma, Alabama. We in Alabama are no stranger to the fight for fair representation. After all, it was in Selma almost 66 decades ago, 60 years ago almost, where John Lewis and so many freedom fighters, known and unknown, shed blood on a bridge in my hometown for the equal right of all Americans to vote. It was their sacrifice that burned in the minds of President Lyndon Johnson as he signed into law the most consequential civil rights legislation of our lifetime, the Voting Rights Act of 1965. But today, we see old battles have become new again. It is because of the Supreme Court that the Voting Rights Act of 1965 is currently on life support as states across this nation race to restrict voter access. The effect of their decision is to further dilute our power and to silence the voices of the minority. And today, in the least of these dirty tricks, extremist politicians and their allies are now trying to cut and undergird Section 2. In Alabama, African Americans make up 27% of the voting bloc, and yet out of the 7 congressional seats, we only have 1. And while I am proud to hold that 1, I know that my state should have more than 1 majority-minority district. It deserves at least 2. Here's why. Fair representation matters. It is never lost on me that I was the sole member of the Alabama delegation to vote in favor of the American Rescue Plan, of the Bipartisan Infrastructure Plan, of the Inflation Reduction Act. All of these pieces of legislation gave more money in the pockets of ordinary Americans. It gave us better health care. It's now going to provide us with better infrastructure. And oh, by the way, because I had a seat at the table, infrastructure is not just roads and bridges. It's broadband and water and sewer, the most important things that are needed in the Black Belt. So I know that fair representation matters, and all we're asking is for our fair share of this piece of the pie. When I think about the struggle that we are currently in, I hearken back to the late, great John Lewis, who said, when you see something that's not right, that's not fair, that's unjust, we have a moral obligation to do something about it. And so I stand with the plaintiffs, Alabama plaintiffs in the Milligan case. I stand with them not because they happen to, some of them happen to be my constituents, because it's the right thing to do. And all we're asking the court to do is to apply the law fairly, and we will win this case. So in closing, I know that every generation must have its own fight in order to protect the progress of the past. I never thought that I would be a member of Congress, a little Black girl from Selma, but for a time such as this, a season such as this, to have my voice at the seat of the table makes a difference, and to have my voice standing here with this wonderful, wonderful diversity of talent and the legal efforts of the NAACP Legal Defense Fund, the ACLU, and others, as well as my courageous plaintiffs in this case. I just want you to know that I stand up for you and I stand with you as we seek fairer representation in Alabama. As John would say, we're getting into some good trouble. Thanks.